Hello and welcome to this video, the seventh one from our course, Introduction to Drafting. We are now going to go through the basic layout and structure of a pleading. In the reading materials to this unit, you can learn about all the essential elements that need to be included in a pleading. In this video, we are going to see a typical plaint, which is a pleading prepared by the plaintiff in a civil case. A plaintiff first approaches a court and outlines their case before a court using a plaint. What we are going to look at is a real plaint. So bear in mind that it is not a perfect one. It has many of the flaws that we observe in the pleadings used in courts today.
So the first piece of essential information we have highlighted here is the name of the court that the suit is in. You can see that there's room there for the court and the location of the court. The second piece of information that is necessary is the name and the description and the place of the residence of both the plaintiff and the defendant. So you can see here, when the parties are outlined, there's also space there for the officers because they're companies in this particular matter. And also the person or people who should be contacted or who are representing the companies in this particular matter. So highlighted there is the two plaintiffs. And then secondly, following that, are the two defendants. The other thing that we've identified in the reading material that is necessary is a statement whether either party is of a minor or of unsound mind. Now that's not the case in this matter, so it's not relevant and it's not included in this plaint.
So thus far, we have seen how to include the name of the court and the names and details of the parties. Let's move on to read the main body of the pleadings.
The next thing that we've identified in the reading material as necessary are a statement of the facts comprising the cause of action and when the action arose. Now, of course, that is quite the substantial part of the plaint, and you'll find in this particular document that paragraphs 3 through to paragraphs 19 of the body of the plaint form that information, so we will take some time to go through those. The next thing that we get to is the facts establishing the court's jurisdiction. Now, within the statement of the facts itself, the court's jurisdiction is established, but in this plaint, there's also a statement of it. If we move all the way down to paragraph 21, you can see here that there's actually a specific paragraph which outlines the court's jurisdiction or alleges the court's jurisdiction in this matter. The next thing that's identified as being an essential element of a plaint is that there must be some statement of the relief claimed. So if you go to the end of this document, you'll see that the plaintiffs state very clearly at the end, which is where it does belong, what orders they're seeking from the court. So you can see there's 3 orders here, and that's quite typical of a civil plaint. The sum that they are seeking in their claim, together with interests. Also costs, you will almost always see costs. And then of course there's the catch-all at the end, any further or other relief and directions. Now that gives a little bit of flexibility in the parties, and it also gives some flexibility to the court if anything else is required. The final thing that we mention as essential part of a plaint in the reading material is a statement of any set-off that the plaintiffs are admitting in the case. Now, that's not the case in this one, but you should note paragraph 23, where the plaintiffs do make a very specific statement that there are no other legal proceedings pending between the parties in any court of law. That's an important, not exactly that requirement, but it is an important element of the plaint.
So far, we have checked the plaint to see whether it has the 4 essential elements. 1. Facts establishing the cause of action and when the cause of action arose. 2. Facts establishing the court's jurisdiction. 3. A statement of the relief claimed. And 4. A statement on set-off, if any. Now that we've seen that this plaint does indeed contain these elements, we should move ahead to see whether the plaint follows the rules of the CPC.
The first thing we need to ask ourselves is, does this plaint state facts as opposed to law? Now, I would say that it does, and I have read through the entire plaint, and you should have already done that, or you'll have the opportunity to do that after this video lecture. But let's just take a look at a couple of paragraphs. Take, for example, the third paragraph, which is the first substantial paragraph when it comes to statements of facts. You'll see here that it just outlines the companies, the nature of the parties involved, and the business that they were undertaking and the relationship between the parties. That's all facts of the matter. Independent companies engage in the business of procuring and selling computer peripherals and networking products. And the defendants were manufacturer and supplier of computer peripherals, accessories and networking products under their brand name. And you'll see that defendant number one assists and advises the defendant number two in the sale of its products in India and elsewhere in neighbouring countries. And you will see that defendant number one assists and advises defendant number two in the sale of its products in India and elsewhere in the neighbouring countries. So that's a very clear statement of the facts. There's no law being pleaded in there. The same thing occurs in the fourth paragraph, where we see how the parties became to be interacting with each other in the business sense. They clearly outline when the arrangement took place, and there is a copy of the agreement in an annexure to the plaint. Now let's go a little further and let's have a look at one more paragraph just to see the pleading of facts. If we look at paragraph 19, we can see it becomes a little more complex. The plaintiffs there are alleging certain wrongdoing on behalf of the defendants, which is obviously the substance of the case. But you can see there that they do allege that the defendants have acted in collusion with one another and are feigning ignorance of certain facts and knowledge. They're alleging certain conduct on behalf of the managing director of the defendant. But they don't quite go so far as to be alleging, for example, the nature of the conduct. They're not pleading any kind of specific law in that paragraph. There's no mention of any legislation that has been breached or any judgments of the court. So that's an example of how the wrongdoing or the particular thing that forms the basis of the plaint can be alleged without pleading any law as such. Now, the next requirement of the CPC is that the plaint state only material facts. Now, of course, we don't know the entire details of the case, so we can't really judge 100% whether whether the plaintiff is only pleading material facts in this case, but it certainly seems so. The plaint is relatively short, and once you read through it, you'll see that the plaintiffs are focusing on setting out the course of the relationship and the interaction between the parties. So we get some paragraphs talking about, back and forth of letters and the conduct of the various parties. That would all seem to be material. Now, another way that we can say that this would seem to be all material facts is there is not a huge amount of time spent talking about lots and lots of different kinds of communication between the parties. You could assume that there may well have been much more communication between the parties, for example, by way of phone calls, perhaps more letters and emails, more invoices, but they're just sticking to the ones that are relevant to establish the cause of action in this case. So it seems that they're complying with that rule of the CPC as well. The third one is that the plaint should only state facts and not evidence. Now again, I would say that this plaint mainly sticks to that rule. The one thing that you may note as an exception is that there are a lot of annexures contained in this plaint. A lot of the letters, copies of the email communications between the parties, as well as a copy of the original contract between the parties, things of that nature have all been annexed. This is a common practice and often done blindly by advocates, or perhaps to try and scare their opponents into retreat. But you can think of it this way. As annexures and copies of documents, they don't strictly fall under the definition of evidence as opposed to, say, an original document referred to as an exhibit. The final requirement from the CPC rules is that the plaint be concise. Now, apart from that being one of the CPC rules, we also know from our unit on persuasive writing that certainly fits in with the rules of persuasive writing. Although this is not an overly short document, it's also not an overly long plaint, and as we've already discussed, it does seem that the plaintiff is sticking to pleading only material facts and not law. So these pleadings do seem to be fairly concise, especially as far as the language goes. There might be some issues with the language in these pleadings, but the conciseness of them I think is fine. As I said before, the substantive paragraphs that contain the facts of the matter only go from 3 through to 19, and then there are some other necessary paragraphs. So I think that they fit within the rule that pleadings should be concise. But let's have a look at some of the language and see if that in itself could be more concise. So for example, if we look at paragraph 6, it's quite long, but the language itself is a little problematic, and given what we've learnt so far in our units, I think we could all do a better job of drafting this paragraph than what's already present. So although the contract for distribution and sale of the defendant's products was entered into only between the defendant number 2 and the plaintiff number 2, over time the defendant number 1 took control of the arrangement and commenced advising and instructing the plaintiff number 1 to instruct the plaintiff number 2 to raise purchase orders on... See, the first sentence only ends here, where I've got the marker on the screen. Now, what I'd like to do as an exercise to go with this video is for us all to have a go at redrafting this clause, and we can post different efforts on the discussion forum. And what you'll see coming up on the screen now is one example from me of how you could redraft this clause. And that just gives us an idea that even when we're presented with a typical plaint and a plaint that doesn't actually have that many problems, we can still improve the writing in it. And we can make the writing more persuasive and more clear by some simple redrafting. So that's something to keep in mind with all plaints or drafts that come across your desk of any kind of pleading, and certainly when you are the one responsible for drafting the pleading yourself.
So now we have also checked the plaint for whether the rules of the Code of Civil Procedure have been followed. To recap, they are: 1. Does the plaint plead law in addition to facts? 2. Does the plaint plead facts that are not material? 3. Does the plaint plead evidence in addition to facts? And finally, 4. Is the plaint concise? Keep these different elements and CPC rules in mind when you draft a pleading or when you review one. Thanks for watching.